Yes, Your Honor. The matter before the court is the case entitled The State of Vermont against Walter M. Taylor III, case number 23AP277. The appellant, Walter M. Taylor, is being represented pro se. The appellee, State of Vermont, is being represented by attorney Evan P. Meenan.
Thanks very much, Mr. Taylor. Can you hear me?
Yes, Your Honor, I can.
All right, good. I can hear you, so please go ahead.
This appeal presents a very straightforward argument. The Windham Criminal Court erred in denying my quorum nobis petition. The state argues the DRs and probation violations were my decision, my fault, so no relief is warranted. My poor choices led to these infractions. But if I never committed a crime, I should have never been in jail. I shouldn't have accumulated DRs, and a probation sentence or violation would have never been imposed. And I wouldn't have been stuck with a serious felony, which this obstruction is. Under Coleman, it's clear obstruction of justice has essential elements of by threats or by force. So I can't be convicted of obstruction of justice. I cannot be convicted under the false report statute because in Aberelli, this honorable court determined that a person needed to be giving false information in order to direct the investigation off of oneself. This act was incredibly stupid and immature and a waste of valuable police time, as well as a nuisance to the community, but it was delinquent, not criminal. I disagree with the state's assertion that the essential elements of by threats or by force is non-existent under the Omnibus Clause. It's my assertion those are still essential elements even under the Omnibus Clause. The state says I'm using this as an appeal to the expungement petition. I'm not. The judge appropriately denied that petition. I wasn't entitled to it. I've picked up new charges since then, and it hadn't been 5 years since it lapsed, so I wasn't entitled to that. I wasn't.
You have to get on. Just let them know you're finna go get on.
They're not gonna let me get on the phone in the middle of a hearing.
I
got 5 minutes to do this.
No, the phone is already on.
Are you guys gonna give me time if you guys move me to a phone? I mean,
you're gonna move to a phone? Is that what you're saying?
Apparently they said I have to. They said you guys want me on a phone.
You're doing fine right now, so you can continue.
Okay. The state says I'm using this as an appeal to the expungement. Okay, I did it. The facts are my ex-girlfriend and I were told by her P&P officer that she couldn't be around me. We were caught together, so she asked me to follow this elaborate plan to say I kidnapped her to protect her from going to jail and prevent DCF from taking our child. During the plea deal, I requested by threats or by force be removed from the obstruction, so the judge scratched it out. Under Coleman, those are essential elements of the crime. That'd be like me agreeing to say that I committed an assault and robbery, but ask him to scratch out the robbery portion of the assault and robbery and saying, okay, I still plead guilty to that. I have no remedy of relief available to me as I am not a prisoner under sentence, leaving quorum nobis as my only option. I'm not under custody as defined in Sinclair because my sentence was not directly enhanced due to this obstruction. It's only an aggravating factor. So looking at a DUI, DUI 1, DUI 2, DUI 3, each one moves itself up by statute. So those are direct enhancements, or a VAPO directly enhance a domestic assault as a misdemeanor, as a felony. That's a direct enhancement. This is just an aggravating factor amongst other factors, but was a strong aggravating factor in deciding what my sentence was. And I shouldn't have to be caught somewhere in the middle just because I'm not eligible for a PCR. That's not in the best interest of justice. Most of the other cases were DUI cases. Remanding in this case doesn't make sense as the behavior was not criminal, yet the state will bully and threaten me into another plea deal. And the officer in charge of this case, Officer Sean Wilson, was charged for being a dirty officer, domestic abuser, and has since committed suicide. So remanding a conviction would be very hard to get, and it doesn't make sense that for remanding. As far as how far quorum nobis goes, whether it addresses whether it addresses legal or just factual errors, it's my understanding of this court's prior decisions regarding quorum nobis that this court refuses to make a decision on how broad quorum nobis can be used in a criminal case.
Mr. Taylor, you
Yep.
have 1 minute. You have 1 minute left.
Okay, how broad quorum nobis can be used in a criminal case without quorum nobis being available. Sinclair has some undeterminate language and is unclear. Head note 1 and another head note in Sinclair are completely argumentative with that factor, and I reserve the rest of my time to read.
Okay. All right. Thank you very much. We'll turn to the counsel for the appellee. Please identify yourself and your client and then proceed.
Good morning, and may it please the court. My name is Evan Meenan, and I represent the state of Vermont, which in this case is asking this court to affirm the dismissal of appellant's quorum nobis petition. In his petition, appellant is seeking relief from his 2018 obstruction of justice conviction on 2 grounds. The first of which is he's claiming he did not act by threats or by force, and he claims that's an essential element of the offense. And his second ground of relief is that he claims his 2018 obstruction of justice conviction was one of the reasons he received a harsher sentence when he was sentenced for a subsequent set of assault and obstruction of justice convictions, which importantly last month, this court affirmed those subsequent convictions. In my time this morning, I'd like to make 2 discrete points to further flesh out the arguments in the state's brief. The first point pertains to the Coleman case, on which the defendant relies to argue that by threats or by force is an essential element of obstruction of justice. This claim and appellant's reliance on the Coleman case is insufficient to warrant a reversal of the trial court's decision. And that's because the appellant was convicted of obstructing justice under the omnibus clause of the statute. And that clause prohibits corruptly endeavoring to impede the due administration of justice. And that clause does not require that appellant act by threats or by force. And it is sufficient that he acted corruptly instead, and that's because of the use of the word or, the disjunctive in the statute. A Coleman is distinguishable because in that case, the defendant was charged under a different clause. He was not charged under the omnibus clause. He was charged under the clause that requires threatening communications. And so under that portion of the statute, by threats or by force was necessary. So it's simply factually distinguishable. The second point that I'd like to make in my time this morning pertains to a case that the state did not cite in its brief and discovered after the fact. And that case is In re Collette, that's Collette, and the public domain citation is 2008 Vermont 136. That case is important because it clarifies the holding in Boskind, which the state did discuss in its brief. And specifically what the Collette case says is that when an individual is or is potentially facing an enhanced sentence because of a previously unchallenged and unappealed prior conviction, that individual can bring a PCR pertaining to the prior conviction, but only to the degree that is being used to enhance the sentence. And it can't be used to challenge the prior conviction itself. Now, the appellant's claim in his quorum nobis petition is that his
Mr. Meenan, so that would be applicable, say, in a DUI 3, a felony, where you could challenge the first or second offense to which would enhance the penalty portion of a DUI 3. Is that?
Yeah, that's mostly correct. You can't. It's sticking with the DUI example because it is a pretty nice and clean example to use. If someone was convicted of DUI 2 and the DUI 1 was being used to enhance the sentence, the individual could bring a PCR to challenge the fact that the DUI 1 is being used as an enhancement. So, for example,
if there was something I don't know, I'm having a hard time getting his words out. If there was something invalid about the DUI one, for example, if it's a change of
Yes.
plea and the Rule 11 colloquy was not done correctly, that there would be some basis to say that that conviction was not valid.
Well, I think you could say that because of the defect in the colloquy, the that conviction can't be used to enhance the sentence for the DUI too. But I don't think in that situation you could actually reverse the DUI 1 conviction, and that's only if the DUI 1 was not previously challenged and not appealed, and that's how you coalesce this court's decisions like Boskind with the decisions that talk about waiving rights to bring collateral challenges to previously unchallenged convictions. And that's why the Collette decision really is such a helpful decision in this particular case. And how it also helps understand the state's discussion of Katie, in which this court held that PCRs are, quote, the correct and only vehicle for defendants seeking to challenge the validity of a plea colloquy in a
All right.
prior conviction. Thank you.
Okay, your time is up. Thank you very much. How much time does the appellant have?
Yes, Your Honor. Appellant has 32 seconds remaining.
Okay, Mr. Taylor.
Sinclair and Katie both talk about an enhanced sentence. Again, this is an aggravating factor, not a directly enhanced sentence. Just like my what I said with the DUI 2, DUI 3, that's exactly right. But this is a different set of circumstances, which is unlike any other. So this isn't like that. And if the court can't see that this is by threats or by force, an essential element, if they could remand it for further proceedings and give me a chance to prove that, I'd appreciate it. Thank you.
Okay, thank you. Your time has expired, and thank